Now I'd like to speak to you about the division between church and state. And the division was established by the First Amendment, which consists of two elements: the Establishment Clause and the Exercise Clause. And it reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." In 1808, Thomas Jefferson wrote a letter to the founders of the Baptist Church, acknowledging the wall of separation between church and state. In 1878, nearly 70 years later, Jefferson's letter would be used to define the word religion in the polygamy trials involving the Mormon Church. The Supreme Court drew a line between religious beliefs, which are untouchable, and religious motivated actions, which can be regulated. In the months to come, the importance and application of the First Amendment will be discussed at length by Proposition 8 proponents and same-sex marriage supporters. The supporters of Prop 8 have proposed that the adoption of same-sex marriage would undermine the very foundations of church and religious beliefs, and therefore violates the First Amendment. On the other hand, under the Establishment Clause, it can be said that the opposition to same-sex marriage is primarily religious, so it can be argued that prohibiting same-sex marriage does in fact violate the advancing religious beliefs of those who oppose it. Under the Exercise Clause, marriage is a religious sacrament, and denying it can be construed as a violation of religious freedom under the First Amendment. Through the course of the last 100 years, the federal court systems have used a variety of methods to evaluate the First Amendment violations. The most prominent four tests are the Lemon test, the historical test, the endorsement test, and the coercion test. Since marriage is a religious sacrament and denying it could be construed as a violation of the Religious Freedom Act under the First Amendment, I couldn't help wondering why neither side of the same-sex marriage debate have claimed that recognition or prohibition of same-sex marriage constitutes an infringement of the free exercise of religion. Well, I finally concluded that there are some religions that allow same-sex marriage, but there are none that actually mandate it. And although it could be suggested that statutes prohibiting same-sex marriage could indeed give rise to violations of the First Amendment, the case itself is not strong enough to be pursued. As it stands, neither the coercion test nor the three other tests provide a clear path for arguing that same-sex marriage bans violate the Establishment Clause or the Exercise Clause of the First Amendment. Same-sex marriage debates exhibit some unusual qualities. The opposition to same-sex marriage is rooted in religious beliefs without ever mentioning religion directly. And the same-sex marriage is a practice prohibited by, rather than mandated by, religious beliefs. And finally, marriage exists across various religious foundations, not just one religion. So because of these qualities, it appears unlikely, despite the evidence, same-sex marriage bans could successfully be challenged under the religious clauses of the First Amendment. Now, if you would like more information about this particular topic, I would recommend that you Google Georgetown Journal, Gods and Gays Analyzing Same-Sex Marriage. Excellent article, fantastic information. The 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The 14th Amendment is comprised of 3 clauses. The Citizenship Clause, which provides a broad definition of citizenship, and this is the clause that allowed all African Americans the right to U.S. citizenship. The Due Process Clause, which prohibits the state and local governments from depriving persons of life, liberty, or property without certain steps being taken to ensure fairness. This clause also ensures the applicability of the Bill of Rights to all the states. And finally, the Equal Protection Clause, which requires each state to provide equal protection under the law to all the people within its jurisdiction. This clause was the basis of the Supreme Court decision which precipitated the dismantling of racial segregation in the United States. The same-sex marriage debate will be settled through the mechanism of the federal court systems, and it will be based on the 14th Amendment. The ban on same-sex marriage violates fundamental principles of equal protection under the law without ever even reaching a religious issue. And now, let's examine Proposition 8. In 2008, 2 groups moved to qualify ballot initiatives to amend the California Constitution. In November, Proposition 8 was passed narrowly by voters. Proposition 8 eliminates the right of same-sex couples to marry, but it does not repeal any rights granted to domestic partnerships, and the registration of domestic partnerships remains legal in California. In 2009, the legality of Proposition 8 was upheld in the California Supreme Court, stating that the same-sex couples have the rights of heterosexual couples, except the right to the designation of marriage, and that such a holding does not violate California's privacy, equal protection, or due process laws. Proposition 8 was then challenged in federal court on August 4th of 2010. It was found to have violated the due process and equal protection clauses of the 14th Amendment of the federal Constitution, which is the equal protection clause requiring California to provide equal protection under the law to all of its people within its jurisdiction. Let's just take a few minutes to review. We've learned that the First Amendment of the Constitution protects the religious freedoms of all people. It does this by requiring the government to be religiously neutral. And we have learned that this will affect the same-sex marriage debate going forward. We have learned the 14th Amendment of the Constitution guards the rights of due process of law and ensures equality to all people in this process. And here we additionally have learned that the bans on same-sex marriage violates the Equal Protection Clause of the 14th Amendment. We've learned that the church views marriage as a religious or spiritual event, and this could differ based on the religious foundations. We've also learned that the state or government views marriage as a business arrangement between 2 people and the state, and all marriages are civil in foundation. The civil unions do not have the same privileges as civil marriages, and it's the solemnization portion of the marriage that gives it its religious aspects, or not. And I'm hoping that I've led you to draw some conclusions. If not, let me help you. Marriage should be redefined and divided into 2 related concepts: civil marriage and religious marriage. We have learned what domestic partnership is, and that it's comparable to civil union, and that it's still legal in California. We've also learned how the federal court evaluates laws and policies that affect religion or that have religious impact on others. As we stand at the crossroads, it's important to take a good look around. we can turn and look behind us and see just how far we've come in the last 2.5 years. As I look back to the year 1999, I see a slow, methodical progression towards equality, and I am absolutely amazed of how far we've traveled, even as I compare it to where we stood a year ago. Just ahead on the road, Governor Brown and Attorney General Harris both refused to appeal the current ruling. They're leaving it up to the proponents of the ban to fight it out for themselves. If the Supreme Court finds that Proposition 8 supporters do not have the right to appeal, the Ninth Circuit has indicated the ruling will stand as is, enabling gay marriages to resume in California as soon as December. However, if the Supreme Court rules that Proposition 8 backers can defend the law on their own, the case will return to the Ninth Circuit, where the judges would then be in a position to resolve the legality of Proposition 8 once and for all. That decision would then tee up gay marriage issues for the U.S. Supreme Court, giving it national implications. Now, here's a few things you should know. You remember Judge Walker. He was the Superior Court judge who passed the ruling that Proposition 8 was unconstitutional based on the 14th Amendment. Judge Walker retired in February of 2011, and on April 6 he told reporters that he is gay. On April 25th, supporters of Proposition 8 filed a motion in district court to vacate Walker's decision. They argued he should have recused himself because he was gay. The appeal was filed based on this fact, and the appeal was not supported by the governor nor the attorney general. The appeal was passed to the Supreme Court in a form of a certified question. And the question was, are they recognized to appeal? So, in September of 2011, the Superior Court will begin hearing arguments based on this question. If they decide that Proposition 8 supporters have the right to appeal, then the reality is this process could take years to settle. During this presentation, I have lightly touched on how religious beliefs are inseparable from the arguments used to oppose same-sex marriage, and from the marriage policy itself throughout history. I have touched on judicial system's religious freedom doctrines, and how a practice primarily motivated by religious beliefs can nevertheless be insulated from challenges of being unconstitutional towards the establishment of religion, or an unconstitutional infringement of the exercise of religion, merely by being an acceptable practice in our culture. I'm hoping this presentation is informative and you would like to hear and see more. It has been my pleasure to speak with you today. If you have suggestions for another topic, please feel free to drop me a line or visit my website. My name is the Reverend Lisa.